Welcome to the Ohio Grandparent Kinship Care Coalition. Thank you for coming. I'm excited. I'm Dr. Ollie Jones. I'm the president, and we're excited about our speaker today, Attorney Baylee Butler. She is the staff attorney at the Southwest Ohio Legal Services of Ohio. She is going to be talking to you about the legal pieces that's attached to kinship care, children, and the providers. Thank you so much.
Thank you so much. So welcome everyone. Like she said, my name is Baylee Butler. I'm a senior staff attorney with Southeastern Ohio Legal Services. Southeastern Ohio Legal Services is a nonprofit law firm. We represent low-income individuals and seniors of any income on civil legal matters. So we don't handle any criminal, but we do a lot of custody, divorces, public benefits, evictions, housing issues, consumer transactions, and different things like that to help out low-income individuals and seniors. So just to get started, this presentation I'm giving is just custody for kinship caregivers, a little bit about custody, and just a little bit more I'll explain about myself. So like I said, I'm with Southeastern Ohio Legal Services. I've been with Southeastern Ohio Legal Services for about 5 years now. I started out working on a project called the Youth Law Project, where I was actually embedded in an organization in Southeastern Ohio called Sojourners, which is a organization that licenses and places children in foster care. And the idea of that organization was to start in Appalachia because there wasn't as many foster parents in Appalachia, and they wanted to keep children in Appalachia in our area. So enabled to, get more people licensed. So they started seeing that kids who were aging out of foster care were aging out into homelessness and having a lot of legal issues after they aged out. So I was actually on site there to talk to their staff and to individuals who were aging out about and train them about different legal options. From there, we received the Appalachian Children's Victims Assistance and Prevention Program from the Department of Justice, which is what this presentation is being funded by from my organization in my time. Which focuses on providing legal services for children and families who have been victims of the opiate crisis or have experienced substance abuse in their family. So we are helping out with any kind of families that are doing, that have children involved. That can include, doing the custody, helping them get public benefits, even education cases with children who might have trauma due to being in a situation that was unstable. So I'm kind of knowledgeable about children in this type of situation. So that's why I was asked to come here and present to you. So what are we going to talk about today? First of all, we're going to define kinship. Kinship can have a lot of different meanings depending on where you are and who you're talking to. We're going to talk about kinship placement through children's services and what that looks like and how that's a little different. We're going to talk about what custody means because it is used often and thrown around, but what does that actually mean? What is the grandparent power of attorney? How is it different from a caretaker authorization? We're going to talk about some basic grandparent rights and then also distinguish it from guardianship. And then I know that we're going to do questions at the end. So if you want to go ahead, I don't know if you want to put those into the chat and then somebody can be monitoring those for me, or if anybody wants to stop me in the middle, I'm happy to take questions whatever is easiest for those of you who are helping out with the tech on this. So I'm going to move on. I know I talk pretty quickly, so if you have any problems or want me to go back and review something, please let me know. But first of all, we're going to talk about what does kinship mean? Kinship can mean a lot of different things. It means different things to a lot of different people. Kinship generally, however, refers to the relationship between the child and the caregiver, where the caregiver is not the child's biological parent. They could be a grandparent, an aunt and uncle, a cousin, a sibling, or what the legal field calls the next friend, which is somebody who is not biologically related to the child, but is kin for all intents and purposes. It could be a family friend. I know growing up, my mom's friends, I always called them my aunt. So I always considered them family, even if they weren't biological or blood related. It can also be like a step grandparent or a step sibling who might not be related by blood, but could be considered a family and a person that should be considered whenever thinking about who should the child be in the custody of. Kinship has a bunch of different legal meanings depending on the group and depending on what the arrangement looks like for each individual circumstances. There are a lot of different names, so I like to call these the unofficial arrangement. So the children just stay with the kinship caregiver part of the time or as needed. The caregiver has no court order or legal rights to the child, but maybe the parent will drop the child off for weeks on end at a time. There's not been any formal arrangement, but there is somebody there that is providing care for the child who's not their biological parent on a regular basis. There's a permanent custody arrangement where the caregiver has custody through a court order. And there's also children's services placement where the caregiver has temporary custody or has physical custody, and the biological parents are working with children's services to have the children returned to their care. So it's not a formal, or it's not a forever relationship is what I mean to say. It is a formal relationship, but it's not a forever relationship. And all the caregiver really has is physical custody. And we will distinguish that from legal custody here in a couple minutes. So kinship placement through children's services, what that looks like is when a child is removed from the home of their biological parent by children's services or a state agency due to allegations of abuse, neglect, or dependency, then children's services or the state agency has an obligation to identify family members who may be willing to temporarily take responsibility for the child. So there's a lot of different placements that can happen in a children's services cases. Ordinarily, children are always with their birth parents. Then if they're not able to be with their birth parents, they go into kinship care where a non-biological parent, family member, kin takes care of the child. If that's not available to the child, or that's not somebody that is able to, there's nobody able to take placement, then they go into foster care, which is somebody, a couple or a person who has been licensed with the state of Ohio, who is non-blood and has no relation to the child, but who the agency who took custody of has an understanding that those people have had a background check, have gone through the whole process of being trained, and are licensed to take children into their home who are not their biological relations. And then if that's not possible, the needs of the child are too severe, or if there's not an available placement, then they could end up in a group or congregate care. But under Ohio law and under federal law, frankly, the most, if a child cannot be with their birth family or the biological parent, then the best place for them to be is with kin. So that is a kinship formal placement through children's services. Keep in mind, however, that the state agency, children's services, has the legal custody. So the state has legal custody of the child. The kinship caregiver only has physical custody of the child at that time. And I do want to just highlight here that a 2018 court order requires children's services in the state to pay kinship caregivers who have a children placed in their home by children's services, similar to what they would pay a foster parent if that child were in foster care. And that usually looks like, that the children are taken by children's services, kinship or kin are identified by the agency, and then the agency does a background check, make sure that the children are safe in that home, does a home visit, and there's a court case open on the biological parents to either get permanent custody for the children or to help them work through their case plan. If that's the case, then their 2018 court order says that the kinship provider in that situation should be receiving a stipend similar to foster parents. So why is custody important, and what does it do, and why is it custody that everyone is always talking about? So custody is just a court order stating who has legal and who has physical custody of the child. Legal custody involves the responsibility for major life decisions that affect the child's life, such as their education, religious upbringing, medical care. It is a legal court order that somebody has the legal right to make those decisions for the child. Physical custody is just who the children live with and what visitation rights do other people have to those children. It is where the child is physically located and who has the right to visit that child. That is the difference between physical and legal. Now, I often hear people come to us all the time and just say, I just need emergency custody. Something terrible has happened and I need emergency custody. Well, at least in our courts, there is no such thing as emergency custody. Emergency custody is often the term that is used interchangeably with temporary custody. Emergency custody means something serious has happened. I need to go to the court right now and file for custody. But because of this terrible thing that has happened, I need to have control and say over what happens to this child right now. So it is the term that is used for an immediate court order stating who should have custody while a longer custody case is pending or while I get ready to file for custody. So it still means that there's going to be a longer custody case down the road. It doesn't mean that it's something that happens and then right now you have custody, boom, today you got it and you're good to go. No, this is in a temporary order that says, okay, there's something terrible that happened. You need custody right now. Here's custody, but we expect you to go to court and file for regular custody, and that child will be in your care while that case is ongoing until a final court order decides permanency for that child. Temporary custody is usually made when you file for custody. So while emergency custody can say, I'm going to file for custody soon, but right now I need this situation, you can file that before you actually file your action. Temporary custody is, I'm filing my action, but I want a court order to say what happens while the case is pending. So custody cases can sometimes take up to a year, maybe longer depending on certain situations. And that child needs some kind of stability. So the temporary order says, this is what happens in the meantime. So that's what temporary custody is. It does not mean that you only have the kids temporarily. If you ask the court for custody, the court's going to assume that you're asking for custody forever, and they're going to assume that a larger custody case is coming. So if you file emergency custody, if you file temporary custody, the court assumption is, and will probably continue to hold hearings and asking you where this paperwork is, that you're going to be filing for a longer custody action for the best interest of that child. So the court's ultimate goal is to give that child permanent stability, not just right now stability. So when you ask for custody, you're asking the court to grant you custody. You're asking the court or you need to show the court that the parents or whoever the child is with currently is unfit. You have to show that it is in the child's best interest that you be granted that custody. And it's important to note that custody is a forever thing in the court's eyes. They want to give that child permanent stability. So you can't just give the child's parents custody, children back to the children's parents whenever you decide. It's not something that you can just say, okay, well, I'm going to take them for now, and then they're going to go and do whatever they're doing, and in a year or so, I'm going to give them custody back. That's not how it works. Once a custody arrangement is made, then in order for anybody or for that custody arrangement to change, there has to be a change in circumstances for the person who has custody. So it doesn't mean that the biological parent, something has changed for them. It doesn't matter that they might have, gone to rehab and gotten things under control. It doesn't matter. They might have been, maybe they're back from the military or they're back from wherever, and that's why there was custody before. It doesn't matter what's going on with the biological parents. If somebody else has custody, in order for the biological parents to get custody back, they have to show a change of circumstances on the person who has custody. And once again, the court is always going to determine what is in the best interest of that child. And for the court, permanency is very, very important. So why should you seek custody? I always tell people that, it's important to think about what custody means and to think of it as a forever thing. It's important to have custody and to make sure that there's some stability in that child's life on a temporary basis. And while things are kind of leveling out and getting stable, if you're not prepared to take care of that child long-term, custody is not the answer, and we need to consider other solutions. So sometimes when you might consider doing custody is maybe you're the sole provider for the child and you plan to continue providing for that child for the long term. That's a good reason to get custody. If the child wants, sorry? Did someone say something? Okay. So the child wants to remain living with you and the parents are constantly threatening to come and take the child. Maybe they've left the child in your care and that's always something that's happening. And then they're saying, okay, well, we're going to come get the child if you don't do X, Y, and Z. Or maybe you're asking them for something and they're saying, well, if you're going to make me do that, then I'm going to come and get the child. If that's a situation and it is providing anxiety, it's causing anxiety for the child, that might be a reason for you to get custody. If the child is not safe with either parent, or if you know that they've been abused, neglected while in their parents' care, that could be another reason to seek custody. Also, just if the child's living with you full time and the parents are absent and you need to be able to get medical care, you need to be able to get care for that child, and you're planning on being that caregiver for that child because you've been that caregiver for that child for many years now, and you're planning on doing it for the future, that could be a reason to get custody. Another reason to consider is if maybe a child's born, but you have custody of that child's siblings because of other situations that are going on, that might also be another reason to get custody of the child. So how do you file for custody? So filing for custody, if a court has already issued a custody order regarding the children, you have to reopen that case in the court where it was filed. Even if the child is living with you in your county and there was a custody order between the biological parents 3 counties over, If that's the case, you still have to go 3 counties over, reopen that case and file, because that court has the history of those children and the case that was going on for those children. So you have to go there. There could be a way for that court to transfer it to your county, but you have to start there. If there has been no court order regarding parents, then it depends on whether or not the parents are married where you file. If the parents were never married, then you file in juvenile court in the county where the child or parent lives. So if the child is living with you and has been living with you for a long period of time, you would file in the juvenile court of your county. If the parents were married or are married, then you have to file in the common pleas court in the county where the child or the parent lives. So like I said, if the child's been living with you, there's been no custody case previously, and the parents are married, you have to go to common pleas court, and that just recently changed. We have paperwork on our website for our counties. We serve 30 counties in southeastern Ohio, but basically the court forms are usually the same. You can go to the Supreme Court website and get the forms as well. You have to file a complaint or motion for custody, a parenting proceeding affidavit, also known as a UCC JEA, which basically gives the court information about where that child has lived previously, what court might have had jurisdiction on other cases, if there's been an abuse, neglect, dependency action, a DV case that child may have been involved in. It gives the court a lot of information about the child and the history of that child in the court process. And then you also have to file a request for service and provide a copy of everything you filed to the parents. So like I said, custody is a serious thing, and you really should consider, when to seek custody. So circumstances where you might not want to seek custody is if you are unable or unwilling to care for that child long-term. If it's not going to be possible for you to have that child 2-3 years from now, custody might not be the way for you to go, and there might be another option for you forward. If the parent is truly and actively working on becoming a better caregiver and a stable parent in that child's life, then that child wants to be with that parent, then you might consider other options rather than custody right now. If that child has a bond with that parent, which in my experience in dealing with kids in all different situations is, regardless of how much that child has been through with that parent, that's still that child's parent, and they still have a bond with them. If that parent is truly and actively working on becoming a better caregiver, and that bond is something that they want to foster with the child, then there might be other options other than custody, which is a more permanent solution to break that parental bond. If the child's safe with their parent, but they need resources to make ends meet, I've had situations where the family has become homeless, but the parents, really want to care for their child and doing the best they can. They just need resources to help, get them safe and get them somewhere housed. That's not necessarily a reason to get custody. It's a reason to help them get to resources and community providers. And another reason that you might not be the right person to get custody is if you have not had a relationship with the child for a long time. If you haven't had a relationship with that child, then, certainly something might need to be done, but the court may not consider you to be the best custody with you to be the best interest of the child if there is somebody else who has a closer relationship who is able to make that child safe and stable. So if custody is not the option for you, or if custody is not right for your individual situation, what are the alternatives? There's a grandparent power of attorney, which is a signed affidavit from the parent granting a grandparent physical custody of the child. It's important, and I want to make sure that we all highlight the word grandparent here, because I often see, older siblings, aunts and uncles, different people trying to get just an affidavit signed because they have custody or they have physical possession of the child right now, and they want to take them to get to the doctor. They want to get them enrolled in school, what have you. But you cannot file an affidavit in Ohio that is an alternative to custody unless you are a grandparent. So a grandparent can use the affidavit to enroll the child in school, to discuss the child's progress in school, to consent to school-related matters like getting them an individual education plan, get them evaluated for special education services, things like that. A grandparent can use this to consent to medical, psychological, or dental treatment of the child, but it does not grant legal custody. The parent still retains all rights to the child and can revoke it at any time. And a grandparent power of attorney can only be used if the parent signs it in front of a notary, and then it has to be filed with the juvenile court. Now, a caretaker affidavit is like a grandparent power of attorney. It is a legal understanding that a grandparent has physical custody of the child. Once again, I want to highlight the word grandparent. It cannot be used for anybody but a grandparent. Now, this is used when the grandparent is unable to locate the parent, but still does not think that custody is right for the given situation. So it's like a grandparent power of attorney, but instead of having the parent sign, the grandparent signs the caretaker authorization stating that they're unable to find the parent to get custody. And you still have to show that you've made reasonable efforts to locate that parent. You've tracked them down on social media, you've looked them up on local court records to see, if what their most recent address is, that you've sent a copy to the most recent address, and that you've tried to be in contact with them at the last known phone number, any kind of friends. You have to show the court that you've done your due diligence in order to find the parent. And if you still can't find the parent, then you file a caretaker authorization. And this grants the grandparent similarly the power to enroll the child in school, discuss the progress, consent to school-related matters, and consent to medical, psychological, and dental treatment. So executing a grandparent power of attorney, it's the same in every county. So we have copies of them on our website. A grandparent power of attorney and a caretaker authorization, you have to file the correct affidavit and the parenting proceeding affidavit. So that's the UCC JEA I talked about previously when you file for custody. You have to file both, and you have to sign the form. Either you sign the form in front of a notary if it's a caretaker authorization, or the parent signs in front of the notary if it's a grandparent power of attorney. You have to notify the parents in writing. So if only one parent gave you permission under a grandparent power of attorney, you have to notify the other parent that you have grandparent power of attorney. If you couldn't find either of them and you had to file the caretaker authorization, you have to notify both of them in writing. And I always recommend people to do it via certified mail so that you get the little stamp that says that you got it back, or that it was delivered, that you get back so you can track it. And then within 5 days of it being signed in front of a notary, then it has to be filed with the juvenile court with that receipt from certified mail or proof that you have mailed it to the parent or the other parents. A grandparent power of attorney can be revoked, like I said, and it can be done anytime in writing. So if the parent believes in the best interest, if the parent believes that they don't want you to have grandparent power of attorney, they can revoke the grandparent power of attorney. So let's say that the parents were married and one of them gave you the grandparent power of attorney, the other one could come over and say, nope, I don't want you to have grandparent power of attorney, and they could revoke it in writing. At that point, if you believe it's in the best interest of the child to remain with you, you can keep physical custody up to 14 days as long as you file for a complaint for custody in court. And you can ask for a temporary orders in that court case so that the court can decide whether or not that child stays with you while the court case is ongoing, or whether they turn them back over to the parents. So that's the rule there. It can also be revoked by the juvenile court. So if for some reason something gets filed in the juvenile court, maybe there's some unruly charges on the child, some other things that show that maybe you're not doing what's best for the child, then the juvenile court can revoke the grandparent power of attorney and turn them back over to their parent or somebody else. It's automatically revoked if the child is no longer living with the grandparent. It's also automatically revoked upon the death of the child or the grandparent. Once terminated, the grandparent must notify the schools, the healthcare providers, court, and the parents so that you cannot continue using that in order to get the child treated. Grandparent visitation rights. So grandparents can receive visitation rights through court orders in certain situations. If the parents are married and they're terminating their marriage, or they're doing a legal separation through the courts, the grandparent can intervene in that case, can join the court case and ask for visitation rights there. If the parent of a child is deceased, so I've had situations where the parents were never married and the father passes away, and then the mother of that child doesn't allow the deceased father's parents to see the child. That situation, they go and they try to get grandparent visitation rights. The other thing is if the child is born to an unmarried woman, like in that situation, and you as the father's parents want visitation with that child, you can file that even if your son doesn't want visitation or doesn't want to see that child. You can still file to have visitation rights. In these cases, it's still up to the courts to determine what is in the best interest of the child. You have to file a motion to establish visitation, and this can be done, like I said, if the court case is ongoing. So if there's an open, divorce, termination, that kind of thing, or an open custody arrangement with the children, with the parents or somebody else, you can intervene in that case by filing that motion right then and there in the current action while it's pending to get a decision. Otherwise, you can file it even though there is no action in the court where the child lives. And usually this is done in the juvenile division unless the parents are married, and then it has to go into the common pleas court. And the last thing I like to talk about whenever I talk about different alternatives to custody is guardianship. But I do want to kind of say guardianship is not really an alternative to custody, but a lot of people use it that way. Guardianship is a probate court order, so not a juvenile court order, not a common pleas order, not a domestic relations court order. It is a probate court order that typically is only used when a child does not have living parents and the child has received some kind of financial award, and somebody needs to kind of monitor that award or keep that trust open for them and make sure that they are taken care of because the parents aren't living. So while the child's living, a guardian has to make sure that they're having the bills paid, the doctor bills paid, that kind of a thing. It's not, like I said, it's not really used, and it's not supposed to be used to replace custody. The court will hold a hearing to determine whether a guardianship is appropriate, and if the person filing for guardianship is a suitable guardian. If that's the case, then the guardian has to submit to fingerprinting, background checks. They have to attend classes every year to understand their fiduciary duties to the child, and they have to make a written report to the court yearly. So there's a lot of different things that have to happen in order for a guardianship to make sense. So that's kind of the things that I wanted to talk about. So if anybody has any questions, I don't know if you want to have them come off mute, or if Lisa or Dr. Jones, if you want to just read off the questions that might have come in. I haven't been able to monitor the chat.
Yes, I can look at some of the questions that's in the chat has already been answered. Thank you, Bart, for responding to some of those. But then there are a question that says, I have custody of my granddaughter. She would like to change her last name to ours. Do we need to get permission from the birth parents to change her last name?
So it really depends on so it's just custody. You don't necessarily have to get permission, but you have to notify them, and they have a right to a hearing. So that's actually something that would get filed in the probate court, and most probate courts have those documents available on their websites to do a change of name. And then you would have to then get everything changed as far as a social security card, any identifiers that child might have. You have to change school records, but you do have to notify them in writing. So you would file something in the court, and then it would also notify the parents. It does go faster if you have their permission. So if they would sign off on that, then, and there's an option for that as well, then it's basically just a file, like a rubber stamp from the court. If they don't sign off, then you have to serve them the papers, similar to like if you were serving them a grandparent power of attorney, do it certified mail, and then they would have an option to request a hearing and explain why they don't feel like that would be appropriate. But I don't know that it would. It really depends on the circumstances. If you've had custody for a very long time, they're not maintaining a relationship, then, and if the child is old enough to express to the court that they want to have that name changed, most of the times the name change will occur.
Okay, thank you. The next question is, can a caregiver petition the court for custody without an attorney?
Yes, absolutely. You do not need to have an attorney. All the forms are available on the Supreme Court's website. I think there's juvenile forms and domestic relations forms on the website. It's pretty self-explanatory. It's all there. It's just kind of blanks that you fill in as far as like who's the parent, what's the date of birth of the child, all that kind of stuff. And you do not need to have an attorney to do it.
Thank you. Okay. And the next question is, what is the difference between permanent custody and legal custody?
So permanent custody is typically what is used for custody, the term for custody of legal custody in a abuse, neglect, dependency action. So in an abuse, neglect, dependency action, the state agency has legal custody. So they're the ones who actually get to make the determination of where the child's going to go to school and whether that child's going to receive special education, whether that child is going to, go to any kind of church. Like technically those decisions can be made and have the right to be made by the state. And then whenever that case is over, the judge in that type of a case determines permanent custody, who has the legal custody on a permanent ongoing basis. Technically, Legal custody, once it is finalized and the final order is done, then that is permanent custody until a judge says otherwise. Some counties, and I know some agencies, use the term permanent custody whenever there are no like parental rights remaining for the parent, but that is not the case in civil custody cases, at least in my experience. Almost every case, the judge will offer some amount of visitation, even if it is just at the caregiver's authorization. So I've had court cases where like the parent had no business having any kind of visitation with the child because of the stuff that parent put the child through. But the judge will still say, if the caretaker, the caregiver who has custody feels it's appropriate, then they can have visitation just because they don't want to sever that bond. The only thing that severs a bond, a parental bond, is adoption. So they like to leave that door open generally. Does that answer the question?
So what you're saying then, with permanent custody, basically it leads to adoption. So if the agency is involved with the child and there's no recourse for this child ever going home, and it may be permanent custody, may be in the best interest of the child, then that becomes an adoptive situation.
Not necessarily. So an adoption is a separate legal action. If they say, okay, well, they're never going back home with the parent, what they turn over, they call it permanent custody because what's happened previously is that the parent that grandparent has had or that kinship caregiver has had temporary custody this whole time while the state agency has had legal custody. They call it permanent custody because it's no longer temporary, and then they're turning over legal custody. So permanent custody in that situation is legal custody. Legal custody is permanent custody, but some agencies, like I said, do try to use that as a more firm thing that says, okay, well, those parental, we've actually taken the child from the parent. And then it kind of signals to, if you file an adoption, it usually signals like, okay, an adoption is really needed in this situation. It's really not any different. I think it's just in how people use it and different agencies use it. But there are no legal differences between legal custody and permanent custody as far as the rights that you have.
Okay, so with legal custody, the Ohio Revised Code says that if there's a change of circumstance with the parent or the child, with the caregiver of the child, the parents may have an opportunity, if they have gotten themselves together, to have that child returned to them if there's a change of circumstances. But you're saying with permanent custody, normally coming out of the child welfare system, with permanent custody, agencies use that when they are going to petition or allow that family to adopt that child. That has historically been the practice.
Yes. But an adoption still has to occur. They still have to go through the court process of doing an adoption.
Correct.
Yes.
Correct. Okay, so I just want some clarification on that. Thank you. Then the next question, this is a long one. Okay, it says, my wife and I were awarded legal custody of our grandson in October of 2016 after Children's Services removed him from his mother's care due to drug use. The legal custody document states the standard for review shall be what is in the best interest of the child. A change of circumstances does not need to be alleged or proven. We have never received support similar to foster care due to means test and income exceeding the threshold. Does that statement in legal custody document preclude us from receiving support? Talking about financial support.
So I'm sorry, read over what the statement in the document was again. I apologize. That was a long one.
What was your question?
What did the statement? It said there doesn't need to be a best interest determination.
Okay, it says my wife and I were awarded legal custody of our grandson in October 2016 after Children's Services removed him from his mother's care due to drug use. The legal custody document states the standard for review shall be what is in the best interest of the child. A change of circumstances does not need to be alleged or proven. We have never received support similar to foster care, talking about financial support, due to the means test income exceeding the threshold. The question then is, does that statement in legal custody document prevent them from receiving financial support?
That statement would not prevent anybody from receiving financial support, but they are a lot of the ways that you would receive financial support would be means tested. So while I mentioned, I think what they might be referring to is when I mentioned that there was a court case in 2018 that said that a child who was removed from their parents and placed in kinship caregivers should receive, and then the kinship caregivers should receive a stipend the same that a foster parent should. That is only true while the case is open. So while that might have been the case, and it sounds like in this case, no, because the court case hadn't happened until 2018, and this person had custody in 2016. But theoretically, while that case was open before you received custody, you might have been eligible for a stipend similar to a foster parent, regardless of means, your means. So for anybody in the situation now, if there's somebody who has, they have physical custody, not legal custody. You have physical custody of the child, and the agency has custody, legal custody, because a court case is still open for an abuse, neglect, dependency action from Children's Services. Then that court case says that you should be receiving a stipend similar to children who are placed in foster care, similar to foster parents, because you're a placement for Children's Services essentially at that point, but only while that case is open. So in this situation, because the case is closed and was closed prior to, frankly, just because the case is closed. Because the case is closed, you're not entitled to that stipend similar to a foster parent, because now they are in your permanent custody. As far as other financial things that you might be entitled to, you could be entitled to child-only benefits, but under Ohio Works First and child-only benefits for TANF, but temporary assistance for needy families. But that is means tested, I believe. And I wish Robin was here because she knows a lot more about those public benefits as far as what you'd be entitled to. But I believe all of them are means tested, other than the stipend while the case is open. And in this case, the case is closed.
Well, she can get the child only benefits without just for the children. She doesn't have to use her income because it would just be for the
Yes.
child. Yes,
that's true.
Okay, thank you so much. The next question is, if I no longer want custody, do I need to go through the courts, or can I just hand the kids back to the parents?
You cannot just hand them off. So once a court has made a determination of custody, then you are the custodian, whether that child is physically with you or not. So you're still going to be the one that gets called if that child is truant. You're going to be the one that gets called if that child does anything unruly, gets picked up by anybody. You're the custodian. You're the one who gets called. You're technically the only one who's allowed to take them and get medical care until that has been changed. So you would have to, somebody else would have to be willing to take custody.
Or basically, if she feels for some reason that she has custody, and she can also contact the Children's Services Agency in her county, and they and have a discussion with them, and then the agency would determine to bring the child back into custody, place and identify, and really talk about why you want this child coming back. Why aren't you able to keep this child and parent this child? It could be a number of reasons. We don't need to know what they are. And then they would look at placing the child somewhere else. So that there are ways to get that done. So going back to the agency, and they're going to look at an abuse, neglect, dependency, or other issues when that goes back to the agency.
The other thing is, if you haven't, that would work if you got the child from Children's Services. If you haven't gotten the child from Children's Services, it really depends on a case-by-case situation on whether or not they would take that child into custody at that point.
They would.
And I think it really depends on each individual county on that situation. If you got the child from a private custody action before Children's Services was ever involved, I think you would have a different response from Children's Services than if the Children's Services had given you the custody. Because
it becomes a neglect. Well,
right.
It becomes a neglect, and so the public agency have to take that child if mom said, if she said, I can't keep this child. So agency have to take the child. So I hope that answered the question, the person who asked the question. Thank you so much. And then the next question says, how does adoption of the child by the caregiver work? I don't understand the question.
So you would have to go through the adoption process, and that's generally in the probate court. I think it depends. You can do one in the juvenile as well. But anyway, it's probate. So you would go through probate, and you would have to prove. There's different things for adoption. And honestly, I didn't look up at those to have those fresh in my mind when I did this presentation. But in order to do the adoption, I know you have to show like that they haven't had any kind of contact with the parent for a significant period of time. The parent hasn't provided anything for them for a significant period of time, and it's due to the parent's like willful absence, I think is like the language that is used. It can't just be like that parent is in jail and hasn't been able to be, do any of the visits. It has to be like the parent was willfully not willing to do the visits, and then you can apply to do an adoption through the probate court, and that parent would have to be notified. And under a new law in Ohio is that parent, if they're unable to afford an attorney, is able to have a public defender, because parental control or having rights to your child, even if you don't have custody of that child, being a parent is still considered an important right that you have, so that you need to have such that you need an attorney appointed for you if that is trying to be taken away.
Okay. This is a similar question, but this one has a little twist to it. If a grandparent has permanent custody and want to adopt their grandchild, what is that process, and is there a home study required?
There would not be a home study required. If you're doing it just through the probate court, it would just be a filing. So you would just file it. The court might appoint a guardian ad litem, which would then determine the best interest of the child, depending on the age of that child. And to be able to talk to that child's like school, to determine, what does that child need, and what is that child's relationship, and that thing, what is it looking like for the child on a case-by-case situation. But honestly, depending on how old the child is like 16, 15, 16, they're able to go in and tell the court, and they don't need a guardian ad litem to tell them what they want, and the judge will usually listen.
Okay. Thank you. The next question is, the Kinship Permanency Incentive Program, the KPI, cash payment are for caregivers who have, I think she's answering your question, I'm sorry. Okay, can a grandparent become a foster parent? Can a grandparent become a foster parent, can become a foster caregiver, even if the intent is only to provide kinship care?
Yes, absolutely. Absolutely, you can. And I believe so. There's been recently, I want to say last year, just last year, Ohio has put in their budget for this year a stipend for kinship placements who have open cases, to pay them a stipend while they get licensed to be a foster parent, and then they can be a foster parent during the remainder of that case and receive a foster care stipend, similar to any other foster care parents. However, I do want to let you know that you are still a licensed foster parent, and you still likely go on the county's, like I said, because this is new, I don't exactly know, but I would assume that you would also go on that county's list of licensed foster parents, and they would still call you for placement. Now, you can always decline those placements, but I would assume that they would still call you, because foster parents are really needed. And then they would also, like any kind of foster parent, they would do, the home studies, and they would send somebody to your home to do some like conversations with the child, which honestly they should be doing whenever they're just in a kinship placement. But I think that's not always the case in every county, at least the ones that I serve.
I don't know if Ron Browder's on the line, but if he is, could you speak some more to that? Because the coalition is working that we do not feel that a kinship care provider should have to become a licensed foster parent to receive 100%. To receive the same monies that a foster parent receives. And so we are challenging some things at the higher level.
Absolutely. And there's currently a class action court case going on that if somebody is interested in joining, I can give you the attorney's information, that they are challenging Ohio's system. Based on the 2018 court case, they're trying to enforce it in Ohio and say that Ohio grandparents under the Title 40, just federal law, that they're entitled to a stipend even if they aren't licensed because they are approved, because they do still have a guard, they do still have a background check, they do still, there's still an open court case. So I completely agree, and I'm with the association on that as well. Currently, Ohio is trying to alleviate that by saying that we will give you like this bridge money until you are licensed. But licensing takes a long time. It takes a lot of training, and it's also giving you, it's putting you on a list that you don't want to be on because all you're trying to provide care to is to your kin. So I agree with that. That's currently what Ohio is doing, and hopefully that class action will move forward and we'll get a better determination shortly.
Does Barb or Ron want to say anything else to this particular issue before we move on if they're on the line?
Well, yeah, Ron's not on, but he has another meeting.
Okay.
But just like Baylee said, the court case that is filed here in Ohio is trying to get the state to pay the foster care payments that are equal to what to kinship caregivers that are equal to what licensed foster parents get. The kinship, this new program that Baylee just mentioned, is paying those caregivers who are working with children's services $10, about $10 a day, which is about $300 a month, which is nowhere near what foster parents get. And then it is requiring, and it's time limited from, it varies. It can be time limited to 9 months or 6 months. And once that time is up, then if the caregiver has not started the process of becoming licensed, those payments stop. Now, while you're getting those payments, you can't receive the child-only benefit. The one thing about these new kinship payments are you can get them for each child in your care. So if you have multiple children, you get $300 per child. Child only, you don't. You get incremental increases based on the child only payments. But once the time frame is up and you haven't become a licensed foster caregiver, then you go back and have to apply for the child only TANF payments. So it's an attempt to try to meet the requirements of the previous lawsuit that was settled, but it is nowhere near meeting those requirements, and that's why the lawsuit was filed.
And if anybody wants connected to that attorney, if they believe they're in that circumstances, they can always email me and I can get you that attorney's information to join that class action if you're interested in being part of that. Our office is not doing it.
Okay, thank you, Barb and attorney. We're gonna go on to the next question, just a couple more. And it says, this is a very different one. I have given this question to say, what can they do if they don't have legal custody and they did not get a stimulus check for the child in their care?
If you do not have legal custody, then so it is based on who filed filed for the child on their, put the child on their taxes previously. So if the child was in your care last year and you received them and you claimed them as being in your care for all of last year, then you should receive the stimulus. If you didn't, then you should reach out to the IRS. I know our office is helping people with that in our service area. We have 30 counties in southeastern Ohio. I don't know if other legal services are doing that. We have a couple tax professionals and to do tax law in our program. I don't know if that's the case in other legal services. I can share with Barb and anybody to share with anybody in this group the legal services breakdown about which legal services agency in your area would serve where you are. But if you're one of ours, you can contact us and we can help you negotiate that with the IRS. But if you don't have legal custody, you didn't file for taxes, then that money went to the person who filed for them or had filed them last year and had that child in their care last year. And that's where it was supposed to go. So unfortunately, you don't have any recourse.
Thank you. This question says, for the Kinship Care Support Program, KPI, does the child needs to be in custody of the public child welfare agency? Yes.
So for the new one,
Maybe.
yes. For KPI, KPI is different. So for the new Kinship Care one that Barb and I were just talking about, that Ohio has, the child has to be in the legal custody of Children's Services, and they have to approve a placement with you as kin. Then you would be eligible for a period of time. That'd be the $300 that Barb was talking about per child a month. And then that's for a period of time, like 6 to 9 months. And if you're not at that point, that is to help to bridge the gap to you then becoming a foster parent. So you should be starting the process to be licensed in order to continue receiving funding. That one, the child has to be in Children's Services. However, for KPI, Kinship Permanency Incentive, which is a different pot of money, a different funding source that you only get, I want to say like up to 6 times you can receive it, and it's a very small amount of money, and it's only for kin who receive permanent custody. So then that can be through Children's Services, and it can also be private custody that you just file on your own. But there has to be a final order of you having custody in order to get those dollars.
So it's legal custody, not permanent custody, because I want to confuse the caregivers, because when we talk about permanent custody, we're thinking about moving toward adoption in the child welfare field. But so we're saying with legal custody, and then they can get it.
Right.
Okay. Just for clarification purpose. A statement for clarification. I was under the impression that training can be waived for kinship families.
Sorry, the impression that what?
That training can be waived for kinship families.
For placement, but not for money. So under the new Kinship Care thing that they started last year, the $300, in order for you to get into, they're not waiving those. I think they're waiving additional, like certain ones, but you still have to go through some amount of training, is my understanding.
Dr. Jones, this is Tara Shook. All of training can be waived for kinship caregivers who are wanting to become licensed foster parents. Pre-service and ongoing training.
Thank you.
Uh-huh.
I appreciate that. I know that there's a lot of rules with all of the changes that they're making with kinship. So it can be overwhelming. This is an interesting one. Are we eligible to join the, yes, you are, the class action suit if we have the child via legal custody? It's just a matter of, you can reach out to the coalition, because the coalition is also actively involved in this process. And we've been having meetings and discussion in terms of looking at what can we do from a state's perspective. So I'm going to encourage those on the line. You get a link whenever we have some type of, not just this type of forum, but when we have our regular coalitions meetings, if you want to get involved, even when we have our weekly support groups that is ran by Ohio State student doing an excellent job, you can get all of that information around kinship care and the things that's going on. So I want to encourage you, kinship care providers, to get involved, because your voices are very powerful. Very powerful. So when you get that email, please reserve to come and be a part of the process. Thank you. I think that was all of the questions here. I think I've covered all of the questions here.
I had a question and I put it in the chat, but you didn't get to it.
Okay, well, I'm sorry. I thought I'd covered all. Go ahead.
No, I had asked the question if I have guardianship, legal guardianship over my grandson, and if I should die because his parents are not able to take care of him, can I put in my will where the child should go so that he doesn't go back to children's services?
You can put it in your will. There is no guarantee that it will be followed. That it doesn't have any legal weight necessarily. The court doesn't have to follow that, especially since you have a guardianship. The court is going to probably, if it's just a guardianship, the court's going to appoint a separate guardian, and since there's a guardianship currently, they would look for another guardian. And some counties, a lot of counties have like institutional or like attorneys that would act as guardians instead. But as far as like who would actually have custody, that would be up to the guardian.
So for point of clarification, so that your type of placement is guardianship, not legal custody?
Well, the papers, I've had him for 6 years, 6.5 years. And I thought, or it said legal guardianship, but I've had him, his mother and father, the courts and everything. We went to court, they gave him to me because the judge actually asked me if I would intervene. And
It
so I
sounds
just,
like legal custody.
Yeah, that sounds like
Okay.
custody.
Yes, ma'am. Mhm.
So yeah, I mean, so like I said, you put it in there. What I would actually do and what I recommend people do is if you know who you would suggest to be the custodian, I would go ahead and talk to them. I would put it in, you'd put it in your will, but then you should also talk to the person who about custody, because they would need to file to get custody upon your passing. So I would explain to them what that process looks like, give them all the forms that you have regarding custody so that they have as much of the information, as much of the story as possible, so that they can take that to the court, and then also give them a copy of your will so they can take that in and use that as more reasons to find that it is in the child's best interest to be with the person that you are designating them to be with. Because if it's custody, whenever they go back to custody, they still have to consider what is in the child's best interest. So as long as they're armed with, it's your wishes that the child be there for X, Y, and Z purpose, for whatever reason, they have a relationship with that child. You need to start building that case as to why they are in the best interest to be in with that person, and make sure that they are equipped to go in immediately upon your passing to get custody.
okay, well, they have all the paperwork as well as my attorney, and we've done the will and we've done a video will so that they know. So,
Great.
okay.
Awesome. That's awesome. Well, thank you so much for your questions, and thank you for being a part of this I'm gonna call it webinar. And before you leave, I want to just give you one announcement, is that our next May 12th presentation will be provided by Kathleen Caffrey, and she is the statewide outreach coordinator for the Ohio Internet Crime Against Children Task Force. Let me say that again. She is the coordinator for the Ohio Internet Crimes Against Children Task Force. This is going to be an exciting webinar that you can learn about cybersecurity in the protection of internet connection systems. And because if you have children or yourself, you're always on the internet. And so we want to make sure that when our children are on the internet, that that their identity or their interaction is being secure. So please put that on your calendar for May the 12th, again at 1:30, same place, same process. And I want to encourage you, invite two people to attend the next webinar. Invite 2 people because we want to get the word out, the information out to grandparents and other kinship care providers who are caring for children, so they have the information to be more informed about how to care and protect the children in their custody. I have 10 grandchildren. Okay, so I've had 2 in placement, and so I've been where you are, and so I want to encourage you, get involved with our monthly meetings. If you have an interest in holding a position, shoot something to us. Let's have a discussion and go further. Anything you want to add, Barb, before we log off?
No, Dr. Jones, I think you've covered everything, and you can either email me or go to the Ohio Grandparent Kinship Coalition website and send an email through that to let me know if you're interested, or let us know if you're interested in participating as one of the positions on the OGKC board. And also, if you want more resources, there's all kinds of resources. This will be posted on the website once it's been edited, so you'll be able to get this. And I think, Baylee, were you going to allow us to post your PowerPoint?
Yeah, I can send that to you along with the document regarding all the other legal aids.
Okay, great. So once we receive that and everything is edited and our technical person gets it ready, it'll be posted to the website. It usually takes a few days, so I'd check probably at the beginning of next week, and it should be posted on the website for those who want to go over it again and get the information from the PowerPoint. But thank you, Baylee, for your presentation. We really appreciate it. It was excellent information.
Absolutely. Thank you all for inviting me.
And thank you for coming. Have a great rest of the afternoon. Take
Thanks,
care.
everyone.